Hello and welcome to this brief legal update from Lightfoot's LLP Solicitors. I'm Ian Norman. I'm a solicitor with Lightfoot's LLP specialising in consumer credit matters and matters of consumer finance. Now, this update is with regard to a new piece of legislation entitled the Mortgage Repossession, Protection of Tenants, etc. Act 2010, which comes into force in England and Wales on the 1st of October 2010. Now, the aim of the Act is to protect unauthorised tenants from eviction as a result of mortgage arrears on mortgages over the property, and this is a situation where a landlord has granted a tenancy to the tenant of property which is mortgaged to the mortgagee, and in granting that tenancy the landlord has failed to get the mortgagee's consent to the tenancy. In normal circumstances, or before the enactment of this piece of legislation, tenants would find themselves in a situation where they would be evicted at very short notice, and this Act aims to give unauthorised tenants new rights and protection. It's a very short piece of legislation, and the key provisions are as follows. Unauthorised tenants will have the formal right to attend possession hearings and to make their case. Now, in the past, district judges have normally allowed unauthorised tenants of property the right to attend possession hearings and make their case. Now they will have a formal right to attend. Now, upon an application by the unauthorised tenant, the court will have the power to suspend the delivery of possession to the mortgagee for a period not exceeding 2 months. And even if a possession order has been made, if an application is made by an unauthorised tenant, the court will have power to stay or suspend the warrant for eviction for a period not exceeding 2 months. Now, for the court to be able to grant such a stay of execution, the unauthorised tenant must have written or must have requested from the mortgagee a undertaking that the mortgagee will not execute the warrant for possession for a period of 2 months, and the mortgagee must have refused to give that written undertaking. Now, in exercising its powers under the Act, the court will have to consider or have regard to any breaches of the unauthorised tenancy by the unauthorised tenant, whether or not those breaches could have been avoided, and also whether those breaches could have been remedied. Also, the court will have the opportunity to make any suspension or adjournment of possession conditional upon the unauthorised tenant paying to the mortgagee an occupation fee for the period of suspension. And the Act stipulates that in those circumstances, no tenancy will be created between the unauthorised tenant and the mortgagee. But how will tenants find out about the proceedings? Well, the Dwelling Houses Execution of Possession Orders by Mortgagee Regulations 2010 will set out in detail, or have set out in detail, they've now been laid before Parliament, will set out in detail exactly what steps need to be taken by mortgagees to give unauthorised tenants notice of the possession proceedings. Now, for more details of the exact steps which need to be taken, please visit our website www.lightfoots.co.uk. Many thanks for listening. Have a good day.